May it please your Lordship. Your Lordship, I beg to mention item number 17. Your Lordship, this is a joint request. Your Lordship, we pray that this matter may come up after 2 weeks, Your Lordship.
Item 17 to 21 are already connected matters.
What is required here?
Here, my lord, in I think item number 18, the petitioner has already argued the matter.
Yes, some matter have been argued by
Yes.
petitioner, some are, yet to be.
Written submissions are yet to be filed in item number 18, which will be filing it. We are seeking some more time to file the submissions.
What about 17?
Your Lordship, 17 is a part heard matter, Your Lordship.
Part heard.
Yes.
17 hasn't been argued yet, madam.
17.
17 hasn't been argued.
Okay,
It's
okay.
CBI's petition. It's yet to be argued.
And 18,
Your Lordship, for 18 written arguments have to
written
be
argument to be filed.
18 written arguments are to be filed, and sorry,
by both
18 and 19 and etc. are yet to be argued.
19, 20, 21.
19, 20,
Yet to be
21.
argued.
2021, my lord, I am for the petitioner, my lord. It was
Not yet
partially argued, but my lord, not concluded, my lord.
Your Lordship, for items number 20 and 21, in fact, the petitioner was supposed to submit some compilation to us.
That, my lord, we have not been able to complete, my lord.
On payment by the parties, this is matter to 2 weeks. So there will be 17 to 20 then.
Your Lordship, 21.
Whatever is required to be done, you do it in the meantime. Or 21. not 21.
Please, your Lordship. Lordship, I beg to mention item number 15. This matter may kindly be taken up after 2 weeks, my lord.
You are for?
I am for the petitioner.
No objection, your Lordship.
On payment by the petitioner, this is matter to 2 weeks.
I do.
May it please your Lordship. Lordship, I beg to mention one unlisted item, Lordship. Lordship, WPC criminal, writ petition criminal 5 of 2022. Right, earlier order, Lordship was pleased to grant liberty to the parties if there is any effective order from the Honorable Supreme Court.
That's that Navamtai matter?
Yes, your Lordship.
So
So I'm making mention, Lordship.
do it Friday.
Supplementary list, item number 1.
Whereas the quashing petition is listed before another bench concerning
It
the
has nothing
same
to do
party.
with this anticipatory bail, my lord. This is nothing.
It's the same matter, my lord. It was listed yesterday and the notice has been issued. My lord, in that matter, my lord Justice Bhattacharjee said that a stay order cannot be passed at this stage and therefore they have moved an anticipatory bail.
My
They
lord, we have
moved the
filed.
quashing FIR.
If my learned friend will allow me to speak, this is my case, let me open the case. She should know the decorum of the court.
But notice has been issued.
Notice has been issued on that, my lord. We say that, my lord, there should not be any, that is for quashing of the FIR, my lord. Here we are for the anticipatory bail, my lord. My lord, we kindly consider this application. My lord, what happened, the background of the case is this, my lord. I was the manager of a warehouse bond, my lord. An agreement was given to me, my lord. Subsequently, my lord, the owner of the warehouse, my lord, has given me an agreement that you invest also in this and you run the show. I run the show, my lord. Subsequently, both the agreement and the power of attorney, my lord, was withdrawn, my lord. Then an NOC was given to me, by which, my lord, I have been discharged from the job of the warehouse, my lord. That NOC is in, my lord, page number 48. My Lord, may kindly come to page 48. Annexure 4, my Lord, page 48. This is letter dated 1st September 2021, my Lord. This is to certify that Sri Gopal Kishan Gaur, I am the petitioner, my Lord, here, has no liabilities or dues towards the business that is Mrs. Gauri Bonded Warehouse and officially released from all his duty, my Lord. Now I have been released, my Lord. Now I have given an agreement, my Lord. That agreement is on next page, my Lord. Page 49, my Lord, if my Lord may kindly see. Now, in my place, my Lord, on the very day, my Lord, 1st September 2021, my Lord, someone else has been appointed as the manager to run the bonded warehouse. If my Lord may kindly see serial number 2 of this agreement, to appear before the concerned authorities and to pay all tax, revenue, fees, etc., and to attend the matter relating to and arising out of the above said business, my Lord. So now, my Lord, is some other person who was running the show, my Lord. My Lord may kindly see now, if my Lord may kindly see the agreement which has been given by me to them, my Lord, that is on page 52.
Yes.
My Lord may kindly see the para 6, my Lord. Para 4, my Lord, first I will read para 4. Whereas the second party was carrying out the business of the above mentioned bonded warehouse since February 2004 till 31st day of August 2021 in the name of the
agreement
first party. Between me and the owner of the bond, my Lord. Whereas the second party was carrying out the business of the above mentioned bonded warehouse since February 2004 till 31st August 2021, my Lord. I was running the show, my Lord, in the name of the first party. Now, my Lord, may kindly skip this next paragraph. Thereafter, my Lord, whereas it has been expressly agreed between both the parties that in near future, if any pending dues, tax, loan, other financial transaction which is due against the above named bonded warehouse during the business transaction operation of the second party, that is from February 2004 to 31st August 2021, my Lord, if any, therefore, shall be exclusively bond paid by the second party, that means I, my Lord. I have given an agreement, my Lord. Now, my Lord, may kindly see the FIR. Before I take, my Lord, to the FIR, my Lord, I will also like to take, my Lord, to page 54, my Lord, Annexure 7. This is on 1st November 2023, my Lord. And my Lord, may kindly see the stamp also.
Oh, this is also agreement.
Yes, this is also an agreement. My Lord, may kindly see who has purchased this stamp by the complainant. It is written there, purchased by the complainant. Now, if my Lord may kindly come to para 4, my Lord. Para 5. And whereas the second party is no longer in a position to run the said business due to other preoccupation with his own business elsewhere, hence after the expiry of the aforesaid agreement, he has handed over the said business in good and serviceable condition back to the first party, who has also cleared all his dues and liabilities toward the said business on payment of the remaining sum has been agreed upon by both the parties, receipt of which is being acknowledged by the first party in the separate sheet. Now, my Lord, when I have been released, my Lord, this agreement was made that there was no dues pending, my Lord. Now, my Lord, may kindly come to the FIR, my Lord, that is page 56, Annexure 8.
Yes.
If my Lord may kindly see second paragraph of the FIR, this FIR is on 7/3/2024, my Lord. Whereas in 2021, I was discharged with all this agreement that I have no liabilities, my Lord. In the year 2021, September month, he has handed over the control, and she is admitting also that 2021 September, I have handed over, my lord, the bonded warehouse to me, stating that all the government dues are clear and the remaining stock in the godown. However, later I learned that the excise duty amounting to crores of rupees is due to the government and the godown was empty. He has misappropriated all the money which are due, and now he has left Meghalaya and his whereabouts are unknown. Further, he has transferred huge sum of money from the bonded account to his own other relatives' account. I seriously doubt that he has also forged my signature. She is doubting, my lord. Now I am not being able to contact him, and he has probably changed his mobile number. The above act of so and so to cheat, misappropriation, fraud, forgery, and steal, and also cheat a person belonging to the ST, my lord. This is the allegation. Now, my lord, may kindly see. My lord, may kindly see the inquiry report, forwarding report given by the police in 2 dates, my lord. The first forwarding report is of dated 14 March 2024, my lord. With due respect, I have the honor and state that I am submitting here with my inquiry report in connection with the above reference GD number. On receipt of the FIR, as you direct, I went to visit the bonded warehouse at so and so, 1.5 kilometer from the PS. By visiting, the complainant state that the month of February 2004, she appointed one so and so, that is the petitioner, my lord, herein, temporary resident of so and so, West Garo Hills, Tura, as the manager, and to look after the warehouse under his full control. Then the above said bonded warehouse was run properly by so and so from 2004 to 2021, my lord. In the month of September 2021, he handed over the warehouse to her and come to know her knowledge that a huge amount of crores of rupees due tax for the government and found that the remaining stock in the godown is empty. This is the allegation, my lord, that this money, crores of money, is pending with the excise department and the godown is empty. My lord, may kindly see. My lord, may kindly see in page 60, my lord. This is a government document, my lord. My lord, we can see officer in charge, excise, and the person who was running the show, my lord. His signature is in the right hand side, and excise department, officer in charge, is in the left hand side. Now, my lord, may kindly see new register monthly stock statement of so and so bonded warehouse for the month of August 2021. 2000 September, my lord, I have left. 2000 September, I left, my lord. Now, my lord, may kindly see the stock. What is there? She said that the bonded warehouse was empty, my lord. Now, these are the stocks, my lord. Now, 31st August 2021, I left, my lord. But this is the opening stock, my lord, may kindly see. The opening stock and the closing stock of August. So, how many bottles were there, my lord? My lord, may kindly see total closing balance for the month of August is this much, my lord.
You see, these are all matters of investigation.
Yes, exactly, my lord. Exactly, my lord.
Tell me what.
Yes. Now, my lord, may kindly see.
What is your prayer?
My point is this, my lord, that if my lord see the series, my lord. Now, if my lord may kindly see the page 63, my lord. 61, 62, 63, my lord. That stock is showing how much stock was there, my lord. Now, if my lord may kindly come to page 63. The opening balance, my lord, this is for the month of September 2021, my lord. Now, I left in August. September, the stocks are still there. Even August, the stocks are there, my lord. And these are all government documents, my lord. How she can say that, my lord, their bonded warehouse was empty, my lord, and that crores of rupees has been withdrawn by me, my lord. Whereas, if the tax of the excise department is not paid yearly, my lord, they doesn't renew the license of the excise department. And if the license is not renewed, my lord, I cannot even open the shop.
When was this case registered?
My lord, 7th March, my lord, FIR. 7th March 2024, and now she is narrating about 2021.
What is the progress of investigation.
My lord, here what happened, my
My
lord?
lord, my
I
lord,
left.
my-
Just
my
let me
lord-
finish. Let me finish.
Just a minute.
Court has registered a case, my lord. And court has directed the IO to investigate into the matter, my lord. Now, my lord, last thing what I want to point out, my lord, is the forwarding report. What she has done, my lord, she has suppressed all the documents that she has issued, my lord. Now she has only given 2 documents, my lord. One is, if my lord may kindly come to page 57, my lord, the first forwarding report. My lord may kindly see and enclosed original FIR and original deed of both the parties.
Yeah, Mr. Day,
Yes, ma'am.
yesterday you were telling me that this.
It has been old act, my lord.
First you say new.
No, my
You said it was under the new
no,
act.
I said, my lord, that there is a judgment which will place, which says, my lord.
And that issue has to be decided.
No, my lord, I will place the judgments, my lord, of the Delhi High Court and Bombay High Court, my lord.
Whatever the case may be, you see,
We-
you are going to the merits of the
My lord,
decision.
my lord,
Whereas what is required to be done in similar matters,
my lord.
bail matters, this court is yet to
Decide
decide on the issue of
whether
the
438 or
old-
the new
yeah,
act.
old code or new code.
Yes,
So that you see, a specific order has to be passed in that regard.
yeah, exactly. my lord.
Thereafter, all these applications will be
And
taken up in due course.
yes, my lord.
But
Now,
yesterday you
If I may make my submission.
you give them just a moment. Yesterday you gave the impression that this is a new case which has been filed. After July.
Yes, exactly, my lord. That is
And
wrong.
then-
That is wrong for me, my lord. I was in the impression that the FIR was filed, my lord. I have cross-checked it. Now, my lord, may kindly see that we have filed an application under 438, my
We'll
lord.
take up this matter later.
Then interim protection may be given, my lord, so that I can
There's no
come.
question of interpretation because the issue is yet to be decided. Though, in fact, if all the parties are, if the parties are ready, we'll take up the hearing on the issue of maintainability
My lord.
as regard the old code and new code.
No, if my lord, this is an application under 438, my lord. If the prosecution has any objection, my lord, then I will rely on this judgment, my lord. This is a
First, the
judgment.
court will have to hear.
Yes.
Parties have to present before the court certain, they were relying on certain decision made by some other high courts, which has to be considered by this court, whether they are applicable or not, whether this court can rely on such decisions or not, and thereafter an order will be. In fact, I'm very keen to dispose of that issue because there's a number of these bail matters coming up. Today also a number of matters have been listed, but I could not pass an effective order. Firstly, because we are waiting for the decision of a division bench.
My lord.
That has been, in fact, yesterday we had passed an order in the division bench, so that issue has been released as far as the division bench is concerned, and it is left to the single bench to take up the matter. So,
What has fallen from the other court, my lord, court number 4, when I was moving for the quashing, he said for interim you can go and file an application for bail, my lord. He has suggested that has fallen from the court, my lord, that I should not quote, and what my learned friend was saying that, my lord, we have failed, that is why you have come here. During the pendency, my lord, you have come. It is not that that matter is disposed of, my lord.
that's a different thing. We will not go into
My lord,
that.
if I may.
Yes,
Fine.
Miss, tell me.
My lord, they had filed a petition for quashing, seeking stay. They did not get stay. They have moved an anticipatory bail. They have a right to move the bail application. I have no problem with that. But I was asked to seek instructions last week whether custody is required or not. The instructions I have received is that they have not been cooperating in the investigation. In fact, he's absconding. He has provided an address of Rajasthan where he could not be found. We were told he is in Hyderabad, and therefore this is the situation in which this bail application is being moved, and therefore it should not be allowed.
See, Miss, before you go again, I don't know whether you have heard me correctly or not.
We will go into the
This court
maintainability
will not.
issue, my lord.
This court will not go into the merits of this matter as of now. What we can do is, the court will hear on the issue of maintainability.
My lord.
Then thereafter we'll.
My lord. Only thing is this, my lord, if I can humbly pray, my lord, there is an inherent power of this honorable court. If minimum protection may be given to me, my lord, otherwise my matter will become infectious if there is.
That I understand that perfectly well.
My
But
lord.
the point is, even then, under which court will the order be passed? Because now, you see, if you refer to the old court, inherent power is there.
Yes, my lord.
And similarly, in the new court, there also would be a new, a similar provision.
Yes.
But the point is, under which, if I resort to any of the court, then that would have settled the matter.
Yes, my lord.
So you understand the predicament that we are in.
Yes, yes, my lord. But
So we'll take up this matter
in
on
similar
Monday.
situated cases, my lord, where Delhi High Court and Bombay High Court has passed an order.
In fact, this court has called upon all members of the bar to make their, at least to apprise the court or help the court in this matter. They are free to address the court as far as that issue is concerned. And Mr. Paul was there the other day. He was willing to assist. Of course, he also has his own matter.
So if all this matter can be tied together and placed before this honorable
We'll
court?
take it up on Monday.
Monday, my lord. Monday. Only, my lord, if I can pray, my lord, that because the gentleman is of 63 years, my lord. He is having some.
I'll not go into because if I go into the merits of the matter, even for passing an interim order, the other side has to be heard. I have to appreciate whatever is said by the respondent.
No, I can understand the difficulty of this honorable court, my lord. Only an observation may fall.
It's Mr. D is FIR of July. Isn't July or
March, my lord.
FIR of March. Now we are in August. Where's the apprehension?
Ask my lord, I have
Where's the apprehension? I don't understand. Anyway, that will be considered.
Only thing is this, my lord. I have taken, my lord, to the various documents, and it is very apparent this is a civil dispute, my lord. It's a contractual that if I fail, then you can. But
let me reiterate myself. I said that issue will not be taken up.
My lord.
We're just wasting time.
My lord.
And the matter was called up for hearing. Mr. SD, Learned Counsel for the petitioner, has advanced his argument on the merits of the case. Ms. S. You're GA? Are you appearing as GA?
Yes, ma'am.
Mr. S.I. GA, appearing for the state respondent, has opposed the submission made by the Learned Counsel for the petitioner. However, at this point of time, it is brought to the notice of this court that the issue of whether the old court, that is the Code of Criminal Procedure 1973, or the new code, that is the I2 full form BNSS 2023, would apply as far as the bail application is concerned, is yet to be decided. Accordingly, with the consent of the parties, the issue of maintainability will be heard firstly on the next date fix.
All the other matters can also be tied together, my lord.
We'll see. This is matter on
Monday.
Monday.
Daily list, item number 1.
My
think
lord,
all
here
this matter
also
will
same similar issue, my lord.
Should only on premier by the parties. This is matter on Monday.
Monday.
So that will be applicable to all these matter 1, 2, 3, 4, 5 and 6.
Yes. 5 and 6.
I see order. On Monday, be prepared to come with
4 and 6.
Lordship, I am appearing for the petitioner in item 2.
I've just passed a blanket order. I believe I am taking the confidence of the members of the bar when I say on prayer made by the parties.
My lord.
I hope nobody is opposing.
Absolutely.
So we'll take it up on Monday.
Deeply.
Item number 7.
Yes, what is required?
Please, Your Lordship, on the last occasion, there was an impleadment petition. Striking of petition was filed by the petitioner.
Oh, that Langrin.
Your Lordship, the petitioner, the respondent number 2, it's against the Darbashno, Your Lordship. So, suspension of it won't be it's not necessary for striking the respondent number 2 as a whole, because the matter is against the Darbashno, Your Lordship, not against the private individual. You could just.
You're appearing for?
I'm for respondent number 3, Your Lordship.
Respondent number 3. Yes, I think earlier the issue was if an application for striking off the name of respondent 2.
Yes, Your Lordship.
Then
for striking off and impleading the new.
Impleading the new or whoever is there. But again, the same would goes to respondent 3.
Yes, Your Lordship.
Because respondent 3 is also, I believe, headed by the same person.
Your Lordship, with regards to that, as per last time, Your Lordship, they said that they were going to seek instruction whether it's the same person or not. Because according to us, it's not the same person, but then they are saying that it's the same person.
Miss, this is your petition.
Yes, Your Lordship.
You have named a certain individual by his name, who was also the same person who appears in as respondent number 2.
Yes, at that time, Your Lordship.
It would appear that he's the same person.
But now, Your Lordship, the thing is that for the Darbar, the acting chief, Your Lordship, he's a completely different person, and for management of the board, it's the same person, the old person who has been suspended from the Darbar.
That is 2.
Yes.
What about 3?
That's what, Your Lordship. 3, as per information, Your Lordship, it's the same person, that N.S. Amyong.
Exactly.
Yes, but now we're impleading for 2, and for 2, it's a different person, Your Lordship.
And 3?
3 will be that same person.
Same person.
Yes.
Okay. That means, okay. So if I'm, let me be clear. As far as this N.S. Amyong is concerned, as far as 3 is concerned, he is the chairman of the
board, management board.
Yes. Okay, fine. So he remains.
Yes.
Whether he is being, suspended or, ousted or whatever, he remains.
I was suspended in a different capacity.
As different capacity as perhaps as same.
Yes.
But you still remain as
the chairman of the board.
So you will remain.
I remain. My only small.
As far as 2 is concerned.
So, my lord, as far as 2 is concerned, they've asked for striking off the name of 2, striking off 2 and impleading a fresh number 2. But my lord, I'll draw lordship's attention to number 2. Who exactly is number 2? Number 2 is the institution of the Darbar, my lord. The Darbar of so-and-so, represented by Shri so-and-so. So the party actually is not the person, it is the institution, my lord. So institution remains, whoever represents can represent. So there's no, I would humbly submit, my lord, there's no necessity to strike off and implead. A simple change in represented by Shri so-and-so instead of Shri Simyong, whoever is the acting chief. Otherwise, it's a...
That is our application, Your Lordship.
That would be, if it is acceptable, then that would be...
It's a simple process, my lord.
A simple process, like you said.
Because the institution, the Darbar is the party, not the person.
Now somebody else is representing the Darbar.
It's like a company, my lord. Reliance company represented by director. If the director dies or some other director comes,
just the name.
The company remains. Similarly, my lord, the Darbar remains.
Have you filed your petition on those lines?
Yes, Your Lordship.
But you have filed a petition to strike off.
Strike off and impleading this person, new person who's.
So now we are saying that it's not required to be struck off. What is required is just for correction. Yes.
Then Your Lordship will do that.
It can be.
Heard Miss Learned Counsel Petitioner and also Mr. S. Jindal, Learned Counsel, appearing for respondent number 2.
Number 3.
3. Who is appearing for 2?
2, my lord. No one had to appear.
Oh. You have not even...
Because we've issued notice, Your Lordship, however, that has not been received because of this problem, Your Lordship. Because he was suspended.
You're making a submission as if you're representing.
No, I was always no. Sorry, my lord. I'm sorry. Maybe it was my fault, but I'm for 3, my lord. I'm for 3.
Who has heard Ms. Letter Counsel for petitioner who has submitted that an application for striking off the respondent number 2 and for impleadment of the proper and necessary party has been filed before this court. Then we'll have to pass that order in the Miss case then. So now the person who is representing the Darbar of Hima Langren is this
Brilliant Henry Samuel.
So he is to be impleaded.
Yes, Your Lordship.
So we'll just change his name.
That's all.
Yes,
That's
Pununto. Petitioner. Namely Shri Brilliant Henry Simyong, who is said to be representing the Darbar of Hima Langren Simship. However, in course of hearing, the Learned Counsel would submit that the respondent number 2 per se is the Darbar of Hima Langren Simship and would be represented by the chief in that capacity, irrespective of a particular individual. This being the case, since at the time of filing of the writ petition, but at the time of filing he was no longer there, was he?
Cannot say, my lord.
Yes, miss?
We just came to learn that he was suspended in...
No, when you filed the petition,
Yes.
was he still the aim then, or was he suspended?
Yes, Your Lordship, but we just came to learn about it after filing.
Suspension was after the institution of the writ. Writ was sometime in June last year.
Okay.
The suspension was in August last year.
That could have been. You could have simply said that.
I'm not sure when was it filed.
June.
The respondent number 2 was represented by Shri N.S. Imyong. However, in due course, that is in the, if I, we'll take it as August.
The writ petition was in June.
No, when was
suspension was on 18th August.
That is in the month of August 2023. He was since suspended as the chief of the Darbar of Hima Langren Simship, and in his place Shri Brilliant Henry Simyong has been placed as the acting chief. It is therefore the prayer of the Learned Counsel that the name of Shri N.S. Simyong be struck off from these proceedings as far as the respondent number 2 is concerned, and in his place, and his name would be replaced by that of Shri Brilliant Henry Simyong. Who's appearing for the collector? Yes. Are you, do you have any objection to the Miss Arkulni G appearing for the collector? Respondent number appearing for respondent number 1, oblique collector, Southwest Khasi Hills, and she as gender appearing for the respondent number 3, Management Board, Lao Ngam. So I can even has no objection to the pre-made and has in fact submitted that the respondent 2 as a whole may not be struck off from these proceedings, but that the petitioner may be directed to make the necessary correction in the petition itself. For simplification of the matter, the court would agree to the submission made. Accordingly, the petitioner is directed to make the necessary correction in the petition itself. The registry to facilitate the same. In the presence of the officers of the registry, you cut it and finish. Accordingly, this petition is disposed of, and the respondent 2 would stand, would remain in the corrected version. And what about the main petition?
Affidavits have been filed.
Oh, you have filed?
We have also filed.
Filed, Your Lordship, both have
Have
received.
you filed your rejoinder?
We'll be filing our rejoinder, Your Lordship.
But my lord, number 2 may have to be issued notice
Yes, Your Lordship.
after amendment, after correction.
Yes, after correction. Upon correction, upon the said correction being made, the petitioner is directed to take steps for issuance of notice upon the said respondent. Respondent number 2. The counsel of the petitioner has submitted that the rejoinder to the counter affidavit filed by the respondent number 1 and 3 respectively could not be filed today. Some time is sought for the same. Pray allow. As prayed for, this is matter up to 2 weeks.
Item number 8.
Your Lordship, I need some time, Your Lordship. I got the Paris comment and now it will go again to the ministry.
What is this matter about?
Regarding the border fencing.
Oh, that border fencing.
Also, also require some more time. Also, I've sent my affidavit to the department for signatures.
You have not filed.
Lordship.
So you are appearing for respondent number 327.
No, Lordship. For 5. Lordship, for 3, 4, 5, 6. Lordship.
What was that?
3 to 7. My apologies.
That's what I said.
My apologies.
It appears that I'm reading the file, whereas you are not, or rather you have not. Anyway, Mr. Arjabnath Leonard, CGC, appearing for the respondent number 1 and 2, has sought for some more time to file the counter affidavit. Similarly, Mr. A.H. Karwanlang, Leonard, additional senior GA, has also sought for time to file the counter affidavit on behalf of the respondent 327. Pray allow. This is matter up to 2 2 weeks.
Item number 9.
Your Lordship, item 9, so I need some time. I'll my activity.
You just to receive instructions.
No, Your Lordship, in this case, what's happened?
You just have to confirm who is the competent authority to swear the affidavit.
No, Your Lordship, in this matter, CEO has been authorized by letter. So I tell this proper authorization will be required in future. So that's why.
So the CEO is to file the affidavit.
CEO is to file instruction has come. So I tell that by letter it will not be proper. So better to have the authorization, because if in future any problem come up, by letter it will be problem. So I have discussed with the CEO and he has written to the ministry.
Right. Mr. Ardebna Leonard CGC has submitted that though it is confirmed, though it has been conveyed to him that the Chief Executive Officer of the Cantonment Board is the competent authority to swear the affidavit on behalf of the respondents number
1 and 2.
1 and 2. However, it is submitted that some time may be allowed for the said respondent to file the affidavit, file the said counter affidavit. On pre-made, this seems allowed. I will not say whether he comes with that is for you.
Just to inform you.
Written authority, that is for you.
Yes. But just I inform because last 2 questions I have taken time. So it is.
As prayed for, this is matter up to 2 weeks.
Item number 10.
Yes.
Lordship, may kindly recall on the last occasion, Lordship had started dictating an order in respect of respondent 2 and 3, based on my humble submission that 2 and 3 owner and driver could not be served, but since it had already gone ex parte in the MSCT proceeding, they are not really required in these proceedings. And Lordship had started dictating the order, but because the 1 month had not expired from issuance of notice, Lordship had said, let's wait for a few days, let the 1 month expire, my lord.
But you're supposed to file fresh
Lordship,
fresh notices.
I noticed the order now. We haven't taken fresh steps, my lord, because the earlier ones had been returned.
So as far as the earlier one is concerned,
yes, my lord.
That's over and done with.
That's true, my lord. If Lordship requires, we'll take fresh steps. This was missed out by us. It was our mistake.
We have to follow the formalities.
Very
Otherwise, what happened is per se.
Yes.
Sorry. Perhaps if the matter, travel
further
then you would be in a difficult position.
In any event, my lord, there's no prayer against driver and owner. But I appreciate what Lordship is saying, that it's better to conduct. We'll take steps.
Mr. S. Jindal, Learned Counsel for the petitioner, appellant has submitted that through inadvertence, the fresh notices could not be issued on the respondents number 2 and 3, respectively. It is prayed that some more time may be allowed for the same, for the said notices to be issued. Pray allowed. Let fresh notice be issued on the said respondent 2 and 3 with returnable within 2 weeks. This is the matter thereafter.
Published.
Item number 11.
Please, Lordship. Lordship, in this matter, we have filed a affidavit, Lordship, bring on record the status report with regard to respondent 3 and 4. Lordship. Yes, sir.
you are supposed to take steps on respondent 2, 3 and
2,
4.
3 and 4, Your Lordship. Yes, Your Lordship. Lordship, with regard to 2, 3 and 4, Lordship, respondent 2 is not, it's returned to the sender, and 2, 3 and 4 is delivered, Your Lordship, to the addressee.
Delivered to?
To addressee, Lordship.
One is not.
No. 2 is not delivered. Lordship,
Two is yet to be affected.
Lordship, we go, Lordship, in my affidavit, Lordship, page 7, Your Lordship, you'll see the report,
Yes.
Your Lordship.
That is only as far as that
Respondent 3 and 4, Your Lordship, it's delivered.
3 and 4, but
Yes,
not
yes,
for
yes.
2. 2
Yes,
is returned to sender.
Sender, Your Lordship. If Your Lordship allow, we'll take a fresh steps, Your Lordship, with regard to respondent.
I had, in fact, given you the option to try and get over this issue, but then you have not come up with anything concrete to allow this court to pass effective orders.
Exactly.
Otherwise, practically speaking, this is just formality.
My lord.
But anyway, since you have,
they are parties.
You have embarked on a judicial process, then that has to be complete.
Yes, Your Lordship.
Mr. Letter Counsel for the petitioner or applicant?
Petitioner, Your Lordship.
Has submitted that the notices issued upon the respondent 3 and 4 respectively has been affected, and an affidavit of service has been filed in this regard. However, as far as the notice issued upon the respondent number
2, Lordship.
Or 2, the note from the post office would indicate that the notice has returned to the sender. It is prayed that the Letter Counsel has submitted that fresh step will be allowed to be taken for that a fresh notice may be allowed to be issued upon the said respondent number 2. On premium, the same is allowed. Let the notice be issued accordingly, returnable within 2 weeks.
It's interim.
Interim continue.
In the meantime, as prayed for, interim order will be made in place. It is, I think, whatever the case may be, we'll see. It is, however, allowed for the petitioner is however allowed to appear before the. Should I do that? That would, just practically because he has to appear before the IO.
Exactly.
He'll be given protection for the, and like I said again, reiterating myself,
True.
The concerned court would
Exactly.
take a call, because this is just anyway, we'll see.
Allah bless.
The interim order will remain in force.
Item number 12.
My lord, in this case, we have filed a missed case seeking for impleadment as the respondent number 6, my lord.
Sir, objection.
And my friend has filed the objection.
Just a moment. So you are the acting
Chief, my lord.
chief now.
Acting Chief. My lord.
And what is this case about?
Yes, relate to my lord, the petitioner.
Your Lordship, I have
was
come before
suspended.
this court regarding the manner in which the inquiry proceedings has been adopted. So, Your Lordship, just to refresh Your Lordship's mind, I will take Your Lordship to the writ petition. I'll just read few paragraphs, not much of Your Lordship's time. Your Lordship will peruse page 23 of my writ petition, paragraph 28. I'll be allowed to read, Your Lordship. Paragraph 28.
Yes.
The petitioner states that upon his suspension, the petitioner herein has been participating in the inquiry and has filed his show cause to the complaint. It is pertinent to state herein that inquiry has already been proceeding for a period of 9 months. However, till date, the inquiry is yet to reach the stage of evidence, owing to the fact that the complainants are filing several applications seeking assistance of the respondent district council in proving the charges against the petitioner. The petitioner has objected to the applications filed by the complainant. However, by order dated so-and-so, Lordship, the inquiry officer has allowed the applications filed by the complainant. Paragraph 29. The petitioner states that it is pertinent to mention herein that for any offence or allegations of any complaint, whether in a criminal proceedings or in service jurisprudence, a procedure is to be adopted as to how the proceedings are to be followed. Such as in a criminal proceedings, when an FIR is filed, the investigating authority inquire into the allegations made, and thereafter completion of such investigation, the investigating inquiry would file the charge sheet against the accused person before competent court, who takes cognizance of the same, and the accused person would appoint a defense counsel of his choice to conduct the criminal proceedings. Similarly, Lordship, page 24. Similarly, departmental proceedings, inquiry officer is appointed to conduct the inquiry, and a presenting officer, PO, being an individual, often from within the organization, appointed to present the case against the charge officer.
Now, what is understood is an inquiry has been instituted against you, and the inquiry is going on. Being aggrieved by such proceedings, you have come